Sometimes like all you want to do is run. Hear me out, hear me out. If all the things you never show, there are the things I want you to know. Secrets start in your heart to slow. But if you don't want to tell me now, I guess I'll never know. Losing almost all my energy. It's getting hard to talk to you, and I'm the only one who speaks. It's all the things you never showed. There are the things I want to know. Secrets start in your heart to slow. But if you don't want to tell me now, I guess I'll never know.
Okay. Hey guys, welcome to the live. And Travis is with us, of course, right now to go over this document that came out and explain it. So welcome, Travis, and welcome you guys to the live.
Thank you for having me, and hello everybody in chat.
Yep. Thank you, Travis. He was having issues with his camera, guys, so we're just gonna take him and pretend like that's I don't know. Who can we pretend you are today? No, just kidding. You can be yourself.
Yeah,
but
just
thank you.
let's see. Trying to have a mental image of, let me think, Randy Quaid. There we go.
Sure. Who's Randy Quaid? And then maybe I should Google him. I don't
No,
know
not
that one.
Randy. Dennis Quaid. Randy
Dennis
Quaid.
Quaid. Dennis Quaid. Okay. Gotcha. Anyways, so thank you guys for joining the live, you guys, today. And again, Travis, let me just bring this up. Again, thank you so much for joining us. Adam's still at work, by the way. So let me just make this a bit bigger, I guess. And wait, I'm making the wrong one bigger, it looks like. I'm supposed to make this one bigger. Sorry, I had the other one open still. But Travis, always, don't you love the first word you see there? Pants on fire. It did give me a good chuckle. You guys all know what that means. But anyways, so yeah, I'll just really let you get into it, Travis, to be honest with you.
That'd be great. So just a little background. What this is in the state of Indiana versus Richard Allen case in the circuit court. The one that Judge Gull is the judge on. So this is, filed in the court where all of the stuff has been happening at the trial court level. All of the commotion about the removal of attorneys and things over the documents. So I know your subscribers, viewers, fans have been watching all of the coverage you've been doing about the recent events. And so they'll be familiar, or at least they will be after we're done with this, that there were two petitions for writ of mandamus filed, one on a Monday and then one a few days later. The first one is the one that we're going to be talking about today. This is the one that was filed by the three attorneys, the main attorney, the Princess of Fucking Darkness about the Access to Court Records Act in Indiana. And that petition for mandamus was asking the Indiana Supreme Court to order the judge to make what I'll call the document dump You can explain that better, what happened with that. But a whole bunch of documents ultimately got released at the request of the media and others. And they were put up on a special website, and but they were never entered into the docket system. And then there were other complaints about other things relating to the court filing system, documents being ordered removed, documents ordered stricken, et cetera, et cetera. So that's what this order is relating to. And so if you could just read that first sentence, Sunny, the part I highlighted, but just go ahead and read all the way the complete sentence.
Oh, sure. Let's see here. So the court has recently reviewed the chronological case summary, CCS, in this cause, and notes that the clerk of the court has not yet made available to the public on the CCS the 118 documents previously made remotely accessible by court order of June 28, 2023. The court previously created a website for these documents as a convenience to the public and the clerk, and to ensure the public has prompt remote access to these documents. The clerk is ordered to enter these documents on the CCS forthwith. Now, sorry, did you want me to read further or stop there?
Nope, that's perfect.
Okay.
So I put no, don't leave it right there where you had it.
Oh yeah, it's there.
Go down just a little bit more where we got pants on fire. So that first sentence, the court has recently reviewed the CCS. You know, what does that sentence mean to you when you read it at the top? I mean, from what's Judge Gull trying to communicate in her order to you?
The court has recently reviewed the chronological case summary.
Yeah, what's that mean to you?
Well, I don't know, the chronological.
Do you think it's like all of a sudden she decided today, you know what, I'm going to check the chronological case summary today, or do you think there's a backstory to that?
Yes.
Yeah. So she writes it like in the same vein as we've had a unforeseen turn of events this morning. I just happened to read the chronological case summary. Yeah, she read the chronological case summary because it was an exhibit to the motion, the petition for writ of mandamus, asking the Indiana Supreme Court to order her to comply with state law. She didn't just review this recently in isolation, but you know, that's why I got pants on fire on there. I found a red X in my stamps. I wish I had the noise. What's that TV show? America's Got Talent.
Yeah, America's Got America's Got Talent. Britain's Got Talent. The big X.
You get three X's and you get the boot, but there's a nasty buzzer sound. No, that ain't flying. So you can scroll down. So the court previously created a website for these documents. So she's backpedaling there to justify, why she did it. And, but that was already pointed out in the petition. They did a good job of presenting a very fair picture of what's been going on with what the judge has been doing with the documents associated with the case that's under the purview of the clerk. And they pointed that out. They said, it was done for this, but these things have never been entered into the system. And, so she's putting that gratuitous language in there. but of course doesn't explain why it's just now that she's doing this. So she orders the clerk to enter those documents forthwith.
Those were the missing documents.
Okay, the next thing is, and I can't recall if this was the subject of the petition for writ of mandamus, whether they asked that these two documents be unsealed or not. I suspect that they probably were. And I bet they're going in order of what was asked for in the petition. And so there's a June 20 filing by the sheriff and a July 5th letter from the Department of Corrections inmate, and place the same in the clerk system. Now, were you guys aware of these documents? Have you talked about these documents? What could they be? Or
honestly, I'm not. Honestly,
it's okay.
Because we've seen so many documents, like the clerk is further ordered to unseal the June 20th, 23 filing, and the July 5th letter from, well, like, I mean, we see things, of course, so we probably seen them where it was like a sealed document or whatever. Because don't you normally still see them on the docket there? Right? They're confidential and then we can't have them. Is that correct?
Yes.
Or not? Yeah. So what exact, like, I mean, obviously we know the Department of Correction is, but just meaning, like, for me personally, I just don't remember at the second what all these documents were.
It doesn't matter. So I have questions to be asked. So those things are going to become unsealed, and you're going to have access to them.
Yeah.
And so what you and others watching will want to be asking is, why were these sealed in the first place? And, should they have been sealed? What was it? And so those are going to be the questions you're going to want to be asking yourself about those documents. Then we've got the motion for the Franks hearing, and she says that those were marked as confidential on the CCS as counsel failed to supply a redacted version at the time of filing. And you'll recall that the attorneys in the first petition for writ of mandamus attached an unredacted version in the Indiana Supreme Court and noted that neither the protective order that had been entered or the discovery order that had been entered, or the gag order, applied to court filings. And so there may still be an issue about this that needs to get resolved with this first writ of mandamus. But there's a whole unredacted version up in the Indiana Supreme Court. I don't know what good it's going to do to file a redacted one. And then I think, there's going to be issue about redacted in accordance with what, the gag order, according to the attorneys for Richard Allen on the petition for writ, said none of the orders apply to court filings. So how do you redact if there's no guidance about that.
Right.
And I thought you or Aspen mentioned that ultimately the court came up with a redacted version on their own, but I may be mistaken about that. But anywho, it doesn't really matter at this point.
Are you talking about the 136 page one?
Yeah.
Yeah, they did. Like that one came out with all the names and everything on it, and then they took it down, and then something about being redacted, and I think I think the last thing I remember was that they ended up just taking it down, but I can't. That part is a blur to me at the moment. But yeah, when it came out, it was like full of everything, like nothing was redacted.
Mm-hmm. So, in any event, that's
Travis, Defense Diaries is in the house. Give a shout out.
Oh, no way.
Yeah, way.
No, this can't be. I mean,
Yes,
we need to flip this around. I need to be watching them. I'd want their take on it. But welcome. Nice to see you guys. Little Bird told me they were down in the Big Easy whooping it up. So they may not be able to think too clear. At least I know it takes me at least 2 days to get my head on straight after I've been down to the Crescent City. So hope they had a great time. And if they're traveling, safe travels. If they're back home, I'm glad to hear that. Anywho, so going on, says if counsel adopts the same, they are ordered to file a redacted version of the pleadings. Again, makes no sense. There's a fully unredacted version up in the Supreme Court. Anybody can look at, just makes no sense. But even if there wasn't, redacted according to what standards? There's no order that applies to court filings. If you believe the Princess of fucking Darkness, which I do, in light of this order complying with nearly everything that they asked for in that petition for writ. So the Princess of fucking Darkness obviously knows that act, and so this is where we are. But how do you redact it? Do you just, we're going to redact the names, or so? Sonny, you're given a paper.
Sorry, 1 sec. The music's going off. Thanks.
Super chat, €2. Thank you.
Thank you, brutally honest. Thank you, Travis. Sorry. Go ahead.
Okay. So I'm going to put you on the spot. You're given a piece of paper, and it's a description of a bunch of things, and you're going to file that with the court, and if there's stuff in there that shouldn't be, you could go to jail for a day or two, or have to pay $1,000 or $2,000. And so what would you want to know about, on how to hide certain words in that document? You'd kind of want a guide, wouldn't you? What's allowed, what's not allowed?
Well, to be honest with you, my first thought would be like, I would think that the lawyers know what's supposed to be redacted from documents that go out. Is that not true?
No, normally, here's what happens normally. That's a very good point. It's one that I did not consider. And so for the lay people out there, anything can be filed, except what's that language? It's in the Federal Code of Civil Procedure.
Well, now just quickly, Travis.
Scandalous matters, just nasty, outright, beyond the pale stuff. You can't put that in there, but that doesn't subject you to contempt automatically. But violating an order subjects you to contempt, willful violation of an order. And so the answer, Sonny, is you look at the order that says these things shall not be filed. And so, no, we don't know. You can file anything. You can file descriptions of photographs. You can file, especially if you're advocating a third-party suspect defense, Saudi, some other dude did it, remember?
Yeah.
You're required in most states, probably every state, to lay out some basic points in order to get that defense on. You have, a motive of the third-party suspect, an opportunity, and a direct connection are the most common ones. So you have to be able to explain why owedness, for example, might be responsible, or I don't know the facts of the case. Certainly not like you, and certainly not like Bob and Allie do. And they can highlight more on this, but certain people were identified in that brief. And again, I'm only 25 pages into it. I've had great excuses not to get to page 26. So I don't know, who they're suggesting, but you have to be able to describe in there who these other people could be. And you have to be able to describe why not including this other information makes the indictment, the warrant, the search warrant, deceptive. So anyway, how do they redact it? And really, there's no way to redact it. And so if I was the attorney in a case like this situation where I didn't have a clear guidance to keep my ass out of jail, or, be fined, or, other stuff, what I would do is I would just submit and say, I'm filing this whole thing under seal. I need clarification. I can't identify what should be redacted because the court's order is ambiguous, not clear. And that's the way it's done in federal court. If, standard protective orders entered and either side designates something as confidential, then you submit either those exhibits under seal, or you redact certain things in the brief. But if you just have no idea, if I was one of the attorneys on the case and I've read the gag order and I've read the protective order, there's no possible way you could begin to redact that Frank's motion, that memo, and have any idea on what you would need to take out or leave in. But
well, Travis, can I just quickly go to a couple of comments that Bob had said, first of all, that it's what's that word? Super fluffieth. Super. I've never even, that's it. You know what?
Let me look over there. It's probably something Allie fed him.
Yeah.
Let me see.
I've never even seen that word, superfluous. Superfluous. I hope I'm not butchering that word, but all I'm thinking about is supercalifragilistic. Okay. But anyways, it says it's all out there. Redacting it serves no purpose. That's clearly
Allie. That's a multi-syllabic word for bullshit.
Is that what that? Oh, okay. That's my new word for today. That's my
what's the rest of the question? The comment?
Well, the comment says it's that word.
It's superfluous. It's superfluous. It's all out there. Redacting it serves no purpose. That was nearly Gull's way of trying to cover her ass.
It says it's all out there. Yeah, redacting it serves no purpose. That's nearly Gull's way of trying to cover her ass. And then the other one. Wait.
I gotta cover my ass. I was quoting defense diaries there.
Yes. And then Wonder Girl said, I believe the onus is on the defense to file a memorandum to support the Frank's motion under seal or file it in a redacted form. Can you please speak to this, Travis, which you just were? Was the court at fault? And then defense diaries, we have zero obligation to redact alternate suspects' names in filings.
Winner, winner, chicken dinner. Yep. So, you know, and I know there's a lot of people, and Aspen's kind of commented on this, that, well, you know, there's people's names in there. There's always
Right.
people's names in there. That, you know, you have to be able to explain to the court why John Doe is the real killer, or why John Doe, the information about John Doe makes for a affidavit in support of a search warrant in compliance with U.S. constitutional safeguards, that it's not a warrant that is misleading or contains, you know, outright lies. I mean, it's, but some people, because of the way she was acting and doing this stuff, think that that's the situation in every case. It's not. This is, what's the word I'm looking for? This, you know, this is the exception, and this is an example of what happens when you make up shit as you go.
Yeah, right. Exactly right. Like what's happened. That's what this is, right? Just
in my view. And anyway, so ethical questions regarding new counsel and past filed motions. And when Bob and Allie do speak on this stuff next, you know, there's in every state, there's at least 2, 3, in Texas it's 4 things that the defendant individually has the absolute right to make the decision on. That's the right whether to plead guilty or not, the right to testify or not testify at his or her trial, and whether they want to waive a jury trial. That's the way in Texas. It may be different elsewhere, but you know, whether they're going to plead not guilty or guilty, that's the defendant's and his alone. But most defendants are going to listen to the advice of their counsel, but it's such an important right that if someone does decide to plead guilty, the court will bring them up, swear them in, and ask the defendant a whole series of questions to make sure that's a free and voluntary decision. And the same if they decide not to testify at trial. Especially at the felony level, they'll take a break, excuse the jury. They'll ask the defendant a series of questions. You know, you understand this is your right. Your attorney can only advise you, make recommendations. So normally, what motions will be filed, not filed, that's typically the strategy call, and the ultimate decision on that is with the attorneys. And but what if, and I hope this happens, I hope since the attorneys on the first writ and certainly the second writ, Kara is one of the attorneys, is the same on both, but that since they represent Mr. Allen, you know, I hope that in some form or fashion, and they can do this ethically, that, look, if you're insistent that you want the Frank's motion as is heard, this is what you need to do. This is the letter you need to send to your attorneys to have that happen. So here's the ethical question. If new counsel gets a letter from Mr. Allen saying, I'm aware of the court's order entered on November 14th, saying that we, meaning me, have to decide whether we want to adopt that, do something else. I'm instructing you to advise the court that we intend to pursue the Frank's motion as is. However, if you think there are things that can be supplemented, added to, I would certainly welcome your, advice and counsel on other things that can be added to that. Now, my personal view is that takes the decision of the attorney whether to pursue a motion or not. It takes it outside their hands and forces them ethically requires them, I should say, to advise the court. Our client has instructed us to pursue that motion, and we intend to do so. And or not even include that our client has instructed us, but we intend to pursue. I think it takes it out of the discretion of the attorneys, and I'm going to be anxious to see if Bob and Allie, what they think about that, or if it's even worthy of discussion. If defendants' new counsel inform the court that they intend to pursue the Frank's motion, the court will schedule a hearing. I have a comment. I guess I was in a snarky mood a little bit earlier today. She really think this is working. Bob and Allie have commented, Kara commented, although she was more reserved, which I can totally understand given the nature of the work she does. But there's been a lot of comments about people who have been following this case closely that she's not deciding things. She's sitting on things and, not deciding this stuff. And, which is why you need the media on this, because the media's job as the attorney walking out the courtroom, I think that may have been Baldwin, the clip. Journalists do your job. They need to point out that this stuff needs to be hammered. And this is not just for Richard Allen. It's generally considered that it's justice for everyone, victims, families, that justice proceed forward and expeditiously as possible, as long as it doesn't jeopardize the rights of the defendant. And, here's more delay, more money. Okay, let's, is there any more questions or comments before we go to the next one?
Well, I was going to say, because we're at the 34-minute mark, and I know that you want to keep it, somewhat short. So I'm just letting you do your thing here, Travis. Where are we at the? Did you?
Yeah, we're at the last page. Finally, the clerk is ordered to place and make accessible on the CCS. Bob talked a whole bunch about this. Former attorneys' pleadings of October 25th, 2023 and October 26th, 2023. Those are the motion to disqualify, and I believe notice of continued representation verified. May be wrong on one of those, but I know the motion to DQ the judge is at least one of them.
Right.
As noted in its prior order, the court considers these pleadings stricken from the record and will not consider those pleadings as the attorneys who filed the same are no longer counsel. But she agreed with what was mentioned in the petition for writ of mandamus, the first one. The clerk is ordered to place and make accessible on CCS former attorney's pleadings.
Yeah.
She had ordered that they be removed. As
Yeah.
Allie's discussed, you just never, ever see that. You
Right.
ordered stricken, and that sounds like, it's removed. You know me, I like to analogize to movies, and one of my favorite ones is because there was good lawyering in this movie, My Cousin Vinny.
Oh, My Cousin Vinny. Yeah.
So Vinny's opening statement in response to the state's opening statement, because he was really tired. So everything that guy said is bullshit. Thank you. And then Herman Munster said, state objected. It's entirely argument, which is a proper objection, by the way. Sustained, everything before the word thank you shall be stricken from the record. Well, it's not actually removed. That's a common notion people have. It's not removed. What it means is it's not accessible by either side as part of the case. You can't
private.
Well, no, it's just it's stricken. So for example, if something's stricken during trial, Mr. Witness, what color was the light? Red or green? At the time of the accident for the other car, and it was red. And for some reason, that was an improper answer, and the court ordered it stricken. During closing argument, neither attorney could make a comment about that. Well, you'll recall witness X, and he testified that the light was, objection, Your Honor, that misstates the evidence, that's arguing outside the record. There's been no testimony, no admissible testimony from witness X what color the light was. Okay, so it's still in the record, but stricken means can't be used in a legal way. Okay, so now we've got another ethical quandary, which we'll save for another time, but the motion to disqualify Gull. So again, these types of motions are generally within the strategy and discretion of the attorneys. That an attorney, if a client says, well, I want you to file a motion saying that I'm a sovereign and therefore the case will be dismissed, or it's an income tax case, I want you to file a motion saying that the Internal Revenue Service and our tax system is unconstitutional under the 14th Amendment. You do not have to listen to your client's wishes in that regard. And in fact, if you do, there's Supreme Court case law that says that's frivolous and in bad faith, and you better not do that. But here again, I hope, and I realize that motion to disqualify is geared more towards decisions relating to how the judge treated and ruled on certain things in reference to prior defense counsel Baldwin and Rozzy. I think I'm saying it the right way, and I'm half my family's from the boot, but
It's Rosie.
Bob pronounces it Rosie, but
It's Rosie.
anyway, I digress. But
Me too. Me too. I say Rosie as well a lot. But anyway, yeah.
Yeah. So I think it can be reshaped. And again, here's the ethical question. If Mr. Allen conveys to his defense attorneys that he wants them to redraft and refile the motion to disqualify, are they required to do so? And it's not the normal ethical analysis, because we have attorneys who they said things that they did with regard to discovery and drips and other things constituted gross negligence, and therefore they were removed from the case. There's been nothing from the court, nothing from anyone that the Frank's memo or the motion to disqualify were frivolous, not meritorious, nothing whatsoever. So you have on the record two lawyers, very accomplished, very experienced, who felt that they were meritorious. How do you come in after the fact as an attorney, and when your client is demanding that both of those things be reasserted, and you simply refuse to do them?
Right.
And I mean, they'd have to tell the court, look, he's instructed us to refile the motion to DQ. We don't think it's meritorious, so we have a legal conflict with our client. We need to withdraw, and you're required to withdraw when that happens. So that there's two sets at minimum of ethical guidelines that are kind of in conflict on this, and this would be a great law exam or bar question on ethics for the next Indiana bar. And so that kind of covers it. I'm 15 minutes over than what I wanted to be. Let's try and answer some questions and comments for 15 minutes. Then we're going to wrap it up.
Wrap it up. That's right. I love it when you take charge. Okay. So Travis, Wonder Girl had said Travis can Scremin and Librato adopt the Frank's motion without the memorandum in support of it.
Yes, they could. They could redraft their entire. They could. Well, that's kind of a loaded question. So there are many, many things argued. I hear, because I'm only 30 pages, and I'm even fudging when I say 30. I'm 25 pages into that thing. What's the analogy?
You ever going to read it, Travis? And be honest. Are you ever going to finish reading that thing? You've been saying that for about a month now, eh?
I'm just gonna wait and see what Bob and Allie say about it. Yeah. then I'll understand it. You have to go too far back into the case, and they've been filing it from the beginning. Like you've been filing it not even before the beginning. I mean, years. There's just too much to know, and I still practice. I don't have the luxury of being an old attorney talking about old cases like some of us, but it's and it wouldn't do the case justice, which means it wouldn't do the girls justice to be able. I can talk about general principles and how they apply and what's really going on here, but to get into the mechanics. So to answer that last question, it's like sausage, and really good sausage. It's got some beef in it. It's got some pork, at least good Italian sausage. Hopefully Bob can attest to
I had
this.
some yesterday, actually.
So, the Italians make the best cold cuts on the planet, period. Anywho, so, they put a lot of different stuff in it, and seasoning and spices. And so this would be like a sausage. And they'd say, yeah, we like the beef, but we don't like pork. Let's pull the pork out of this sausage and then rewrap it in the casing. It would be extremely difficult. They could draft a whole new one and still call it Frank's. I think the way that you'd do it, if you thought that there were some things in there that were meritorious, others that you didn't want to pursue, you'd just say, yeah, we're reasserting the motion. However, we're going to file a supplement where we're going to specifically identify certain issues and the things indexed and, subpoints, sub-subpoints, headings, subheadings, sub-subheadings, sub-sub-subheadings, even has a syllabus at the top. It'd be easy to go through and identify for the court that we don't intend to pursue this or that. But correct me if I'm wrong, last time I read, there were thousands of pages of exhibits and umpteen hours of audio and video that she was slowly going through. That was a mere 2.5 weeks ago. She's now all of a sudden ready to have a hearing. God bless the ability to file a petition for writ of mandamus.
All right. I appreciate your analogy of the, sausage and beef. I thought we were totally going in a different direction with the topic at hand here for a second.
Oh, good Lord.
I know, and then you said Frank.
Mind out of that gutter.
No, it went there, okay? I think a lot of people's did.
Oh, good Lord.
Okay, keeping it classy. Wonder Girl says, I consider the memorandum akin to throwing crap at the wall to see what will stick, and an astounding board from what the defense will actually use at trial.
And that is fine to have that opinion, and a lot of people will have that opinion more like on the trial, that the defense doesn't have a cohesive theme, cohesive theory. And if you don't have a cohesive theme from jury selection, voir dire, all the way through, it appears to outsiders, especially a jury, that you're just throwing everything at the wall and you see what sticks, which, what we're looking at, you're trying to raise a reasonable doubt. But that's why it's essential to be effective. You have a theme and you stick to that theme, and everything ties into that theme. The theme may be some other dude did it. Now, with respect to a motion, in this Frank's motion and memorandum in support of, there's criteria, there's requirements, and the requirements are initially set forth in this case, the U.S. Supreme Court case, Franks v. Delaware, that said, this is what happens if the defendant believes that there are lies contained in the affidavit in support of search warrant. And there's a process, and it gets refined in other cases and so on and so forth. And so it's not really that situation that you're throwing everything in that sticks. I think what really the other comments, criticisms about the memo is that it contains a lot of information that may not relate to a Frank's hearing, and therefore, doesn't belong in there. And, I don't know. If there is, the proper response from the state is, guess what? A motion to strike. And, the court would go through that and strike the stuff. Courts are always trying to narrow the issues at the time of the hearing. If there's things that are agreed upon, they'll ask attorneys, okay, do we really need to go over this? It seems pretty clear that this happened, like the date of the search warrant. Do we really need to go through that this is an accurate copy of the search warrant affidavit? Does the state have any exceptions that they're going to be arguing that they didn't even need a search warrant, that there was some exception to the Fourth Amendment that, makes all of this unnecessary? And so a good judge will lay out, what are we arguing here? What are we fighting about? And while it may be true that there's a lot in there, at this stage, it's not really a case of they're throwing everything at the wall that sticks. They may have put a bunch of stuff in there that turns out isn't necessary to make a determination on what they're asking the court to decide. But, we'll see on that later, maybe.
Travis, do you think that they're trying to get the search warrant out because there's like evidence that is incriminating to perhaps Richard Allen, and that's why they're trying so hard?
No. So again, a Frank's motion is the classic case is detectives put together this search warrant and they have to lay out facts that show the judge who's reviewing it that there's probable cause to enter a person's castle against their consent. And that, so you have to have at least probable cause to do that, and you have to lay out facts. And believe it or not, there are situations where misguided detectives make up shit. They copy and paste stuff from 15 years of other affidavits. They just copy and paste. And there's just outright lies in there. And so the U.S. Supreme Court said, we have this thing, it's called the Fourth Amendment. No warrant shall issue except upon probable cause. And so what the court is required to do, they just look at the four corners of the search warrant, specifically the affidavit in support. They hear witnesses. If they find that the person who swore that the affidavit was true were untrue, they strike out that part of the affidavit. Then they reread it and say, is there still probable cause or is there no probable cause? Now, this is a highly specific type of Frank's motion. And there's a body of law that says it doesn't have to be an outright lie. If the overall affidavit is so highly deceptive that if a magistrate, that's the person who reads the neutral and detached magistrate who's reading the affidavit knew that information, they would have said, wait a minute. I don't think you have enough here. Now, that's what they're trying to do. And then what was discovered in the search? I presume the gun that got linked to the unfired shell casing. So the gun's a pretty important piece of evidence. If they win on the Franks motion, the gun's out, period. And because that's the fruit of the poisonous tree, that's a whole 5 days worth of talks about Map v. Ohio and the exclusionary rule and yada, 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 yada. So, but no, they are claiming there's a constitutional violation, AKA technicality, that their clients' constitutional rights were violated, to be free from unreasonable search and seizures. Because, I won't pick on you, but, we were under tyranny not too long ago in this country, 250 years ago. The British could go in any home at any time. They could knock on your door and say, we're tired, we're going to sleep here for the night. What's for dinner? That shit really happened. And so, this stuff we call technicalities, this stuff's important. And they are saying there's a constitutional violation, and we want you to hear witnesses about it, make a determination. And if you find that we're correct, we want you to suppress any evidence that was found as a result of that search warrant. And so it's fruit of poisonous tree. So that means if they found something and then that led them to another piece of evidence that they wouldn't have been able to find hadn't they not violated constitutional rights, that's out too. But the main thing here is they're trying to get the gun excluded. Now, if there is a potential on any constitutional violation, it's a lawyer's absolute fundamental obligation to raise the issue and have it heard. It's just a fundamental. That's one of your jobs as an attorney, pre-trial and during trial. One, you have to conduct your own investigation. You have an ethical duty to investigate the facts of the case. You can't just rely on what the state's discovery says. You have to go out and you have to poke and prod and confirm and investigate.
Right.
Absolutely. You have a duty to investigate. Then you have a duty to preserve error. And even if, and the state of law may be in flux, and so you preserve that. That's how the law progresses. The law is not static. Thermal imaging, for example, that happened, just 20 years ago. The FBI and other federal agencies, they could go by your home and shoot special thermal imaging cameras inside the home to see where people were located, generally what they were doing. The images aren't clear. And the ruse was that, well, we use that for the safety of our officers when they're conducting a search, but they were using that stuff, saying through thermal imaging, we're able to locate, this person's coming and going and this is happening and yada, yada, yada. And Supreme Court said, no, that's an invasion of a man's or woman's castle. You can't use thermal imaging to do that. You got to get a warrant. you got to get a warrant before you start listening in on
Right.
people's conversations and whatnot. So, I mean, and until some lawyer snapped and said, well, yeah, there's no case against thermal imaging, but that just can't be right. Some lawyer somewhere said, this is bullshit, to quote a very famous lawyer in Chicago on commenting upon rulings. Not that anyone could hear, but it's fucking bullshit. So you file a motion, and if a search warrant based on thermal imaging is what got the warrant, you would file a Frank's motion, and if they lied about it, and then if not, you would file a different Fourth Amendment motion. But in any event, somebody raised that somewhere, and it went all the way up to the United States Supreme Court, because it's a cat and mouse game, especially in high level narcotics. It's the government comes up with means of detection, and the cartels and other people develop countermeasures, and it's a pretty big battle back and forth. The same with my era in the 80s with organized crime and all of those types of things. It was a constant battle back and forth between there's no such thing as the mafia, but organized crime that might have a particular nationality involved. It was a battle back and forth, cat and mouse, and so that's how these things happen. Some bright lawyer files it, and as we talk later, I can give 100 examples of this. Is a 911 call. Does that deny someone the right of confrontation? Is that testimonial? And on and on and on and on. What's the next? What's
The only thing
This is our thing here. This is the ombudsman order.
From Diner, right? Judge Diner, chicken.
Okay, so there's standard order, and you're running the mill case, domestic violence, possession of methamphetamine, drug cases in rural Indiana. From what I've seen, there's a lot of meth cases, a lot of drug cases, and they have a standing order that all discovery be produced. So he entered a standard order, and in that court, provide all discovery 2 weeks before the trial. In most run-of-the-mill cases, that will work. However, not in a case like this. You can't be getting the volume of the discovery that I've heard in this case 2 weeks before trial. And we know that. How do we know that? The attorneys who replaced Baldwin and Rozzi for now hadn't even seen it, but heard about it. We know what they told the court. We're going to need at least until October, November. And so she bumped it out 9 months, said, yeah, that's reasonable. So, then the other little trick game that prosecutors do is they dribble out discovery that they've just had forever. And it's a game with them. And what they try to do is throw you off. And while you're trying to get prepared for trial, and the 2-3 weeks before trial, this is going to require at least And oh, did we give you the audio of your client on the phone to his wife? We have 87 hours of audio that we can't remember if we gave it to you or not. They just do shit like this all the time.
Right. Yeah.
It puts you on, to borrow from Bob, gives you Hobson's choice. Do we seek a continuance because there's no way we can listen to all of this, or do we just proceed on and do the best we can? And so Baldwin and Rozzi, who have been around the block a time or two, filed a motion to set a discovery deadline saying everything on this case needs to be filed by early November. I can't remember the date, 11/1, whatever. And that would give us at least 2.5 months to prepare this case. And that's what it's going to require. And we can't be getting, absent a compelling reason, we call it good cause, absent good cause, nothing, no more discovery after November 1, let's say. And she granted that. That's the order in place as of now. It superseded the order you have up there right now.
Oh, great. Okay.
And however, we know, so if those attorneys are going to stay on the case, they need to get the court to amend its order setting a discovery deadline. If it were me, I'd say, or to clarify that that remains in place, the discovery order's in effect. And, if they come up with something new, they need to show good cause why it wasn't produced before. Now, I think the court, in light of if that continuance stands, I think the court, but who knows, would set a new discovery deadline 2.5 months before the trial date. But that's gone this 2 weeks before trial. So what's in effect right now is there's no more discovery. Someone's going to have to go in and get the judge to say that's null and void, or something else. But right now, if there was something that came in and they produced it to the other side, it doesn't come in at trial unless they can show good cause why it wasn't produced before November 1. That's my reading on it. I'm sure Bob and Allie are more familiar with the history of it and whatnot. They might have a different view of it.
Ignore Charmaine's question, okay?
Oh, I always answer Charmaine's question. Okay, let's see. Sorry if this has been asked and answered. That's a legal objection, by the way. But I'm wondering if Travis read the entire. No, Charmaine. Somebody was talking about cooking pot roast in a crock pot the other day, and I asked for the recipe in a chat, and no one responded. I got.
Is that what that was about? I was wondering what that comment was. I thought you were trying to tell me that guess who's cooking pot roast right now?
I'm trying to trade, something to get that recipe. No, I have not, Charmaine. I'm no further into that thing than I was the last time we talked, and I said I'm up to about page 26. I'm not.
Yeah.
But
okay. Well, Tom Webster dropped his videos, but it's in members today. He dropped his Tom Webster. You know who Tom Webster is, right?
Who?
Tom Webster. Have you ever seen his channel?
I don't know who Tom Webster is unless
Oh,
it's
okay.
Noah's uncle.
You would love him. He's well organized. He besides his fascination with me, not really so much Adam, but with me. But anyway, so he dropped
Good
his
Lord.
deal.
I mean, this show,
It's true.
fascination,
It's true.
infatuation,
Yeah.
sausage.
Well,
Um,
it ha-
it's
you
always
steered
entertaining.
you
Always.
steered that one. Okay, I'm just gonna say that I mean, I could easily have steered that, but you steered the sausage and franks and beef and in and out thing. But no, so Tom Webster is just a great creator. He's very methodical in how he does things, with his spread points. So, anyways, save your brain power, and when you do have time. When Tom releases it to the public, because it's in his members right now, he's gone over that 136-page memorandum and dissected it. Like, you'd appreciate Tom. I'm telling you that. Anyway,
Thanks for the tip, and I just might do that. But I'm gonna
well,
try and
I don't trust you ever going to read it anyway.
negotiate some recipes out of this deal.
Oh my God, there's Deb again. We need to stop this live right now, Deb, let's come back to this planet in reality. All right. Anyway, that's a private joke, Travis. Because when Tom comes in here, like I said, most people that follow Delphi and that know exactly who Tom Webster is. And again, he does great work, great guy. And so we always fight for his attention, but clearly he loves me more. That's all anyone needs to know. Other than that, Travis, I know unless you have anything more to say, I know you want to get going here. So I'm sorry that we couldn't answer everybody's questions that are out there. It would really be nice when you have time, though, Travis, just to do one of those lives where it's just let them ask questions about the, court documents and proceedings in general.
Yeah, so we got 2 dates coming up on that. And one is the 27th, the Monday after the Thanksgiving holiday.
Oh, yeah.
No, they don't have Thanksgiving in the UK.
Yes, they
don't
do.
know what you saw, but don't mislead your husband and make him feel guilty. Thanksgiving is a holiday for the new world, giving thanks for the new land that God provided them to colonize and bring the word of God, or whatever. They didn't need that in the UK. Now, in the UK, there are numerous holidays of Thanksgiving from the Anglican Church. So they give thanksgiving for what God has provided them, but there's no specific Thanksgiving holiday.
So you're going to tell me that Google is lying to me?
You show it to me, and I have
Fine.
many cousins in Scotland, is where we're from. The other half's from the boot, but
The boot, yeah.
so, but no, there's no there's no holiday of Thanksgiving that like we have, but they have many religious days of Thanksgiving.
I want to say this to you. When I Googled that, right, whatever thing I hit first on Google, it said yes, and it was like the same day as United States, right? So I just Googled it now. Shock horror to my belief. It says the UK in Britain, we do not celebrate Thanksgiving. Oh my God. Shock and horror of it all. Because my husband, I said to him, you must have noticed some turkeys or window decorations or something.
You need to make him an extra special dessert tonight because I know you made him feel bad that he grew up in the UK and didn't know that there was a Thanksgiving holiday, but it doesn't exist. I know what you read probably, and and if you skimmed it, it talks about, there are many days of Thanksgiving in the UK. Yeah. It would be very, very easy to misread that. They're religious days of Thanksgiving in the Anglican Church,
Well,
which is the
I'm
Church of England. In the U.S., that's the Episcopalian Church.
I was going to say, I will go back and tell my husband, because there was two people from the UK.
No, you got to make a dessert. You can't just
Well, sure, if
try
it
and make
includes
up for it with words.
franks and
Actions
beef.
speak louder than words.
Sure, you're right. Sausage, beef, and sausage and franks. You're right. They do speak louder than words. So that will be the dessert. Okay, promises. I will completely make that dessert. All right. All right. Okay.
How you all handle your
Yeah.
business and but I'm glad that you're a big enough person that you can admit when you're wrong, and you don't need to backpedal and say, oh, I was recently reviewing the court's
Yeah.
ECS printout and noticed you know
Yeah.
you know
Bullshit. I know. Bullshit.
You-
Bullshit.
you're a much bigger person
Then
than
Mrs. Fran Gull. Thank you. Thank you.
well, you said it, not me, but
I know. Now, just one last question. Who said about the pot roast? Do you remember the name? The guilty party that's in here that didn't answer you back? I feel so bad for you, really.
somebody saying that yeah, I've got a pot roast in the crock pot that I'm going to need, that's been cooking all day, that I need to
Yeah, it was
go
probably
take
Deb.
care of. I can't remember. Could have been in
It was Deb.
Bob and Allie's or one of yours, but
Yeah.
I know you're super punctual on getting that dinner, ready. And so I just have a feeling you and Charmaine are like excellent cooks. And
Oh, sure. If it comes out of M&Ms or a box and I can throw it in the oven, I'm marvelous at doing that. You're right. To be honest with you, Travis, my dinner that my husband made me has been sitting behind me for the last hour, and then he messaged me from his computer in the living room to say, "Just so you know, baby, your dinner's behind you."
dang,
I know.
unbelievable,
He's such a horrible
unbelievable.
husband. Horrible. But anyways, I need to let you go because I know you got to get going, and I don't want to keep you, even though I can talk as long as you needed to. But yeah.
So the big question is, so does this render the entire petition for writ of mandamus, the first one, moot? I recall there's a couple of more things that they asked for, but the ladies, including the Princess of Fucking Darkness, who was the main author of it, will evaluate what the judge has done and then determine whether they've gotten enough that they wanted, and so they may file something after that they've seen these things done. They ask for some stuff about the waivers being filed, so they still may want to. There's certain forms you're supposed to attach if you want to keep things sealed. So I don't know if they covered everything or not. So there may be still some stuff to talk about, but it's clear that Judge Gull just wasn't happening to go through the things. She had to sit down with her lawyer, who's very well versed in that same act, that legislation, about what needs to be public, if things are going to be sealed or confidential. There's a process, and sat down and said, I think they're clearly right on these things. You may want to consider. And she just didn't want to say, I read the petition for writ, and I agree these things need to be taken care of, and I'm ordering them to be done immediately. But, people respond to things differently. And, people can take from what she says and does what they will. But so there may be still more to argue about, or they may say these items are rendered moot. So we may see a supplemental brief from the relator, which is Richard Allen's attorneys,
Yeah.
saying these issues appear to be satisfied. This is what's left.
Yeah.
Yeah. So another conversation, either the Monday after Thanksgiving, which they don't celebrate in the UK, but they do in Canada, the US,
Ours
Aruba,
is in
other
October,
Commonwealth
Yeah.
former colonies, or after the court makes their decision, one or the other. But we'll talk about that.
And just quickly, I was really gonna sit here and beg people to go to Deb's her true crime notebook there, the link. And then she made fun and made me like Sunny cooking. Ha 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 ha. And I was just about to put this link down, which I did anyway. You guys, Deb's at 972 subscribers. She needs to get to 1,000. That's 28. Can you guys please go to Deb's True Crime Notebook? She's a good friend of ours. She used to be on the channel here. Can you guys do her that favor for anyone that's watching the stream? Get her to 1,000 subscribers tonight if you could. Also, I don't like to beg, grovel, and plead and whatever, but I'm really sick and tired of sitting underneath the 10K. Why? Because I'm just sick and tired of sitting underneath 10K for like the last 3 months, sitting like about 100 and something away from it. But now we're like 28 away from it. So I hate to use like force and, or I'm not a good beggar. But if you could just beg for me, Travis, that'd be great. We just need like
It'd make me feel a lot better. It would help my ego. There's 131 people in here.
I know.
And only 86 likes. That's telling me that
I appreciate you.
Only 75% of the people like what I have to say.
You got to get me into the.
I may not sleep well tonight.
I get it. I haven't slept well in a long time myself. I get it. But the injustice of it all, correct? I mean, this is a crime and shame. Yeah.
Don't blame Sunny for what I have to say. You probably need a disclaimer you pop up right about now. The views expressed by our guests are not necessarily the official views of It's a Crime and Shame.
Recipes only, people.
Don't send me mail. My battery is running low on my laptop. I may just click off, but that's the way we roll around here. So thank you for having me, sincerely.
Thank you.
And, thank you. Somebody at least learned one new thing that caught it. And
super flipperious.
We're at 90 minutes. You got dinner ready. I hope you get the dessert you're hoping for. And
I'll get the dessert I'm hoping for. Sure will. Okay. Thank you, Travis.
Okay. We'll see y'all soon. Everybody be safe. We'll talk to you. Bye.
Bye, Travis. Whew. Now we can talk. Now we can really talk. Oh, he's still here. No, now we can talk, guys. No, just kidding. All right. I was thinking, watch, Adam's going to pop on like just as Travis is about to pop off. But yeah, if you guys could give a like, that would be very kind of you guys to do that, please. We totally appreciate it when something that's a lot of out of our elements. And I'm sorry we didn't get to more questions than that tonight, but Travis didn't want to be too long tonight on those questions. But it's so nice when he can come and hopefully give you guys the understanding and stuff like that, as well as the other podcasters as well. So, who's messaging me? Somebody's messaging me thick right now. I do. Oh, okay. No. I mean, we can do another live later, perhaps, or something. I don't know. Sorry, that's just Travis begging me. He's like, "Oh, Sonny, I miss you already. I can come back on after dinner." Anyways, yeah, let's get, if you guys could, just like, I'm being sincere now. If you guys could really help Deb out on her channel there, and just like I said, she's so close. Let's see, does anyone go subscribe yet? I mean, it really, oh, 977. Come on, people. Come on. Can we sit here till Deb gets 1,000? Can you guys do that? Go over to this link, hold on right there, and do that. You know, if you're at it and you're not sub to this channel, perhaps, you know. Yeah, I got a 10K video that's been waiting a week to play, people, okay? None of this, you know, 88, 89, oh, back down, 87, 86, oh, back up, 89. Yeah, it's like people are messing with me. Yeah, but anyways, I'm already subbed to Deb. Well, just make another account there, Ellen, and sub again. That's right. Yeah, I've used my accounts. I have a couple different accounts, to be honest. I've got a little bit of stuff of content on them and all that stuff. But if you do, that will be great. Just, you know, it's like Deb's been waiting forever just to hit that cherry on top, haven't you, Deb? Yeah, you see how it wasn't hard to bribe you, was it? No, just kidding. Anyways, you guys, oops, messages. See, look at this. I'm wanted. Somebody wants me. Let's see. Who's that one? Oh, no, it's just my message telling me on there. I don't know. Right now, I'm just hanging with you for a minute. To be honest with you, I'm just seeing if Deb can reach. You guys, maybe tonight, if you guys get us to 10K, I can play the video. 978, Deb. 22 away, Deb. Defense Diaries is going live in 30 minutes. The investigation search for additional Casey victims. Ooh. Hey, don't forget, you guys, there's a video that I sent to my Twitter and that like that. And it says, what was it? Brian Koberger. Just different change of thought for a second. Aspen Connor, I was about to join, but saw y'all wrapping up. So key witness to testify in Brian Koberger's murder trial. It says, I think it was on Tuesday or something like that. Anyways, I shared the link to Facebook group and to the It's a Crime and Shame page and to the Twitter and stuff like that. So if you haven't seen that, that should be very interesting. Sunny, what's for dinner? I'm pretty sure if I turn around and it's behind me, I'm pretty sure that it is probably that chicken broccoli pasty bake thing that you throw in the oven. You know, the one that I worked hard all day slaving to make, right? On there. To be honest with you, I've been watching a lot of Gordon Ramsay videos lately, and he's inspired me to get my ass off of my computer desk and sometimes create some stuff for my husband. You know, I actually don't mind making stuff. No, I'm not a cook by no means, to be honest. I don't mind cooking certain things, but it's like a chore. Laundry, it's like a chore. Cleaning, it's like a chore. You know, playing on the computer, making videos, not so much a chore. Yeah. I think it's, you guys, I think this is honestly stems from my mother. When we were younger, my mom, she would, like, I remember being like 5 years old, sitting there with the ironing board, ironing the freaking clothes. Where the frick irons their clothes, like their shirts? You literally had to iron all your shirts. My mom was a neat freak. I think I rebelled on that once I moved out, and I just never cared since, to be honest with you. Cleaning, creating videos. I don't know. It's not really a hard option there. Can someone please sum up docs? No, you gotta go rewind, Shelly. And listen, my brain has no power in it right now, by the way. You guys, just to be honest with you, I think I've legitly had 1 hour sleep. I did not sleep at all last night. I was too busy doing stuff on my iPad and stuff like that and talking that I literally never even slept. And then when I did sleep, it was only for an hour. And then this document popped up. And then I was like, hey, Travis, come on, want to do a live? Yeah. Don't understand what he was saying. Sorry. On there. Well, basically, I mean, the gist of it is that, yeah, Deb, if you could just type that all out, that would be awesome. The gist of it is that, Fran Gull, obviously misstepped, and hence why liar, kind of pants on fire. She misstepped, and she has to put documents back, and the documents are going to get released. That was like 118 or whatever it was. So basically, some documents, how do I explain this fast? Some of the court documents that were stricken from the attorneys will have to get put back into, the docket or whatever. So basically, the gist of it was in these particular orders, it's basically Fran Gull having to fix her mistakes that she did in these documents and putting files properly back on the docket where they belong, certain ones to be, unsealed, and some to remain still sealed because they're not redacted properly. So, Sunny, maybe some onion. Sunny, get some rest. No. I got a few different wins. You know what? It's a real hard life when you literally go 2 feet from your bed to your computer. Yeah, I'm think I'm pretty good. It's not like my husband who has to get up at 4:30 in the morning and stuff like that. One day I'll quit being a hobo and get a job again. I've worked all my life, and it's been just over a year since I lost my job. I was working in optical, because of like the economy. Because in optical, like the 2-year thing was coming around from the COVID. Anyways, it was a great job. I don't want to say it was a great job. It was and it wasn't, because I freaking hate working with people that are freaking so dramatic and always, you know what I mean? Just go to work and be happy, okay? How hard is that? Instead of being bitchy, whiny, fucking negative people all day. But anyways, it was like 2 minutes away. I literally just crossed over the bridge and there it was. So pretty much my husband, he's been loving me a lot. Yeah. So, but I keep sending resumes out. But you know what? 54 people, 54 is not that ripe age. They go, yeah, you know what? You've been a general manager of a hotel and you've done all this stuff and you've had your own businesses and blah, blah, blah. Yeah, no, sorry. Moving on to the next application. So sorry. Throw a few out there. Right. You know how it is. Someone just has to look at your application and go, oh, yeah, we want someone that's going to be here for 30 years with us, not another like 5 to 10, pretty much. Anyways, it doesn't change anything with the Supreme Court. I'm sorry. I'm just trying to see what you guys are saying. Hi, Duckin. I'm behind, but I always make my roasts in a crock pot. Right. A lot of people do. Most people do. A lot of people do. Or perhaps Deb an air fryer. Change anything with the courts. Yeah. Adam's still watching this. He's just jealous that I got you guys all to myself. Or else he's just enjoying himself eating and having a smoke or something like that instead. Yeah. Adam, come pop on. Come pop on. The people of the land want to see you and hear from you. Yeah. Right? Wait, let's see how many subs does Deb have. We're sitting here till Deb gets 1,000. Come on now. 978. Come on, guys. This is a very nice woman right here. You see that picture with the air fryer? Okay. That's one of those people that is a true caring individual of this world. Behind me, of course. Someone sent me Sunny's air fryer. Smart ass. A new CCK summary needs to be provided that will include the 118 documents. Yeah. I think that they should just open up the whole case for us, evidence and all. And, we'll decide if there's enough evidence against Richard Allen or not. I don't have an issue with that. Adam. Can you believe it? If Adam's not on right now, it's because he's not watching us anymore, Deb. He doesn't care about us. Yeah, he's like, yeah, I'm going for a smoke. I should probably go eat my dinner, I suppose. One sec. Motion for Franks. One sec. Talk amongst yourselves for a second. Oh yeah, I thought I muted myself. I guess I didn't. I was just asking Adam if he's gonna come on, but he's pretending he doesn't care and love us anymore. Now let's just see here. Nope. Let's see here. Nope. Deb. I'm still sitting at 9,982. No one loved this. No one loves us. They're watching, but some of them don't love us as much. They're just here for the info only, sadly. Deb, did you go up anymore? Let me just hit refresh. That's okay. And I guess I can go improve my 10K video for me and Adam. It's fine. Don't love you guys anyway. Anyway, Gil Hurd. Thank you. Shoot. Give me a sec. Who else was that? I was, I should put his timestamp on the end part here. Sorry, I'll be right there. Just need to look at something because was it Gil Hurd twice? No, brutally honest. Thank you. It was brutally honest. That was it. Brutally honest. Thank you for that $2 super sticker and Gail Hurd for the $4 super sticker. Thank you guys. Angela, thank you for joining us. Look at Ben. Ben, you're such a great mod. I love it. We'll get there, Deb. Right. Yeah, we got this. We got this. But anyways, okay, well, Adam didn't answer me. I'm going to get off. Perhaps we will do another live tonight. Perhaps we won't. I'm not really sure. I'm going to go eat my dinner that my husband made me that's now freezing cold. And or go heat it up or something. And other than that, thank you guys so much. And if you truly can, if you're not subscribed to the channel, consider subscribing. And if you guys could please go over to Deb's channel as well. All the links are in the description of the video in the live once it ends. They're always in every single video. Okay, guys. And I do want to thank again the Miracle for Missing for those beautiful pictures. And I want to thank Charmaine for sending it to Christy, Kaylee's mom. Nobody does that. Sending that a sweet video. It's always nice when people, think beyond that it's the case that just gets talked about. That, when you do those little small things, sometimes that are very meaningful to the family instead of all the, maybe trash talking of the case and just that people do nice, whether it's a picture or a video, doesn't matter. Those are always things that are sweet to do for other people, for sure. So that was very nice of Charmaine to do that. And don't forget, you guys, whoever hasn't seen it and is a member of Tom Webster's members group there, the video has been released. It's 7 hours and 20 minutes long or something like that. And Charmaine, you know what's funny, Charmaine, is I see a heart and then it's like 4 boxes. But that's probably because I'm in StreamYard or whatever. But anyways, we might be back later, might not sure, you guys. Thank you guys. Mwah. And you guys have a great night, and thanks for joining. And here comes the outro. This is Sunny Justice and Aspen Connor from it. Hold on a second. And thank you again, Travis. Sorry, I hit the thing and I was like on there. But thank you guys for doing that. Thanks, Travis, for doing that tonight. All right, intro time. This is Sunny Justice and Aspen Connor from It's a Crime and Shame, wishing you all a good night. I almost did it again. I was too busy looking at the comments that I played the extra and I forgot to end the stream. So now I'm going to end just the stream. I don't know why, but I've done that like 3 times in the last month. It's like, I get so, yeah, I know. I'm just going to end the stream now. Bye, guys.